Hello.
Greetings.
Greetings. How's your day?
It's going pretty good so far. Just not getting any work done. Too many calls.
Well, I
I'm waiting.
understand, and I apologize, but
No, not that. I had three more go in when you called me. So I generally I get up real early and do my work. I wait till 8 o'clock. My phone blows up.
okay.
So
All right. In your lawsuit, you're stating that the JP court has jurisdiction due to 27.031 of the Code of Criminal Procedure. The problem is 27.031 is in direct violation of the Texas Constitution.
27.031.
It's the one that says that the JP courts have jurisdiction over civil suits for $20,000 or less.
Yeah.
The Texas Constitution says their limit is $200 or less.
That has been updated.
No, it has not. That is what the Constitution says. What
Well,
they have tried to do, that's the second clause of that section of the Constitution.
Oh, okay, but we're going to leave that alone because I don't want to fight that right now because I just
understand that, but I'm just trying to tell you something here. If you let me get it finished with it.
Okay.
What they have done in creating 27.031 is they have used the third clause of the constitutional article to attempt to nullify the second clause of the same constitutional article.
That's an interesting argument.
Well, you remember where they said they can't interpret the law or the statute so as to invalidate any other portion of the Constitution, laws, or whatever?
Russo v. State.
Yeah, well, that's exactly what they're doing with 27.031.
So the Russo v. State's a good argument to make. You cannot interpret one statute in such a way that it renders another statute superfluous.
Correct. And that's what they're doing with this constitutional section over the jurisdiction of the JP courts in civil cases. The second clause of the section in the Constitution where it is says their monetary limit is $200 or less. The third clause says, and other things in accordance with law. Where they're trying to use the in accordance with law section in the third clause to invalidate the second clause.
Yeah, but the law cannot be written such that it violates constitutional provision.
Correct. And that's exactly what 27.031 does.
Okay, that's a good argument.
But the problem is you are hanging your jurisdictional basis on that statute. You're claiming the JP court has jurisdiction to hear this case because of that statute. And that's the problem.
It's not a problem if they don't argue it.
Well, until somebody...
I get your point.
Well, here's the thing.
No. Wait. No. You're speaking to the authority of a magistrate to hear a civil case.
Yes.
That's not a magistrate duty. That's a justice of the peace duty. You're calling the justice of the peace magistrate. Not the same.
Randy, when you're filing a lawsuit, you're not invoking their duty as a magistrate. You're invoking it as a judge. And you're saying they have jurisdiction to hear it as a judge based on this statute.
Wait a minute. Are you looking at my big lawsuit or the one I just filed Monday?
Your template for your program against a judge.
Oh, okay. That's the one you're talking about. Oh, okay. Yeah, in that case, I am invoking not the magistrate's duty, but I'm invoking the justice of the peace duty.
Right.
Okay. That's a good argument. Just don't tell the other side.
Well, here's the thing. Here's what I see happening. Let's say you win and they appeal. Your judgment is going to be shot right between the eyes when the appellate court rules they can't do it.
There's no way the appellate court is going to overrule that. They're going to tell them to go fuck themselves. Just like your claim against the ordinances. There's no way they're going to go there. They're going to tell these guys to go fuck yourself. If we want JPs to be able to handle up to 20,000, you're not going to fuck with it.
Well, the thing is without amending the Constitution, they can't give them that power. And that's the problem. There is no constitutional amendment changing the money amount that JPs can preside over.
Okay, that's what I thought they had done. But if they haven't done that, then you're right. It's not valid.
Yeah, no, they haven't changed the Constitution. They used a statute to do it.
So I'll wait until I get one of them to sue me in the JP court. And then blow it out from under them. Oh, that'd be fun. That would be great fun. So have you read the suit?
We're reading through it. We started it in class last night. I haven't read your suit, but I was going through your template for your program last night for the same reasons.
All I'm saying is that I gave criminal complaints to a magistrate. The magistrate refused to issue warrants under 15.09.
Right, but you've got another flawed argument in that suit under 1509. 1509 is divided up into two parts. The first part is permissive. It says may transfer the complaint.
What? No,
yes, it does. The first part of 1509 says a complaint may be transferred. The second part is what invokes the duty once it has been transferred.
So I'm transferring. I'm filing it with the magistrate myself. So he has it. The first part it becomes irrelevant.
That's correct.
I said the may part.
That's correct.
To my purpose, that's irrelevant.
But you're not making that distinction when you're making your argument in that suit.
I don't need to. I'm not arguing, briefing every possible argument for them. Screw that. If they want to bring that issue, let them. Then I'll argue this.
Yeah, but the problem is, Randy, is that you go down in your argument and you talk about the transfer.
Yeah.
Okay, as being a mandatory duty, and it's not.
No, I didn't talk about the transfer as being a mandatory duty.
Randy, we went through it in class last night and went over it multiple times.
Okay, I have to go with that. I have never said
that may not be your intention, but that is what you've written.
Where? What have you got it there?
Hang on. Let me pull it up.
I'm speaking to a fact set where the filing with the magistrate has already been made. I never spoke to what the conditions of transferring are. Only that they must be, that they're listed. The fact that I gave it to it myself nullifies all that.
Okay. The complaint may be forwarded. And this is what you say, and this is your original suit. This is without my changes to it. Said refusal to perform under defendant's contract with the state had the effect of shielding the accused from prosecution in violation of the Texas Penal Code, which reads as follows. And then you go into hindering apprehension and prosecution. But you just make a said refusal. You don't differentiate between the two sections of this statute.
I don't care about the first section of the statute.
But
it's not
you
relevant.
cite it. That's my point.
It's still not relevant to the consideration. I don't have to prove up something because it's in the law. I couldn't chop up the law and only put part of it in there. I had to put all of the law in there. So I just left it in there. I didn't cut it apart. When I quote the law, I quote the law. I don't go and quote pieces of it.
Well, the problem is when you're making it. Okay, hang on. You're also saying that it's an administrative duty, which the second part is not. It's a non-discretionary legal duty.
That makes it administrative. It's administrative because he has, and this is what the Civil Practice and Remedies Code addresses: a duty over which the court has no discretion is an administrative duty.
That's out of what?
It's a Civil Practice and Remedies Code. I think it's in 104.002 or 3.
Hang on, let me pull up.
I'm not sure exactly where that is. I have to look up administrative duty. But in either case, regardless of what it is, the judge was commanded specifically to do a certain thing. The judge failed to do the certain thing he was commanded to do. That's a crime in the state of Texas.
What section do you think it is?
104.002. The one that comes. They use 104.001 for immunity, but it doesn't say immunity. It says indemnity. And then I think 104.002 is the one that said you could sue them.
State liability conduct covered. Except as provided by the subsection B, the state is liable for indemnification under this chapter only if the damages are based on an act or omission by the person in the course and scope of the person's office, employment, or contractual performance for or service on behalf of the agency, institution, or department, and if the damages arise, indemnification is the interest, the person is liable for the damage solely, the person signed the manifest, the person or company. I don't see anything in here about what defines an administrative duty.
I'll have to look that up. I don't have that. What is an administrative in Texas law? Let me go to ChatGTP. Okay, according to Texas Administrative Code, 1977, administrative agencies are authorized. Responsibility of state agency or commission to that's not helpful. I'll have to look it up. Okay. Oh wait, I should have a section in my research repository. Generally, how do you think they'll respond to it?
Well, from what I've read so far, I think they're not going to respond to it at all, other than saying it doesn't facilitate any relevant claim. But I haven't got to read through the whole thing yet. I only started going. Julie forwarded it to me right before class, so I just brought it up as a subject for the class so we could go through it last night, and I think we got to I don't know, page 6, 7, or 8. I forget which. But I was going through and reading it and then looking to see what the arguments were, et cetera, et cetera. And so far, these are the things that jumped out at me, is that 1509 has both a permissive and a non-discretionary component. And they have to be differentiated between when you're making your argument.
I did. I addressed the non-discretionary.
Well, but there's nothing.
His failure.
Yeah, but
he failed.
Okay, but what I'm saying is there's nothing that points to that specific section of that statute that you're saying this is the duty he was required to comply with.
What? You need to read the rest of it then, because that is.
Well, I'm working on it.
That is precisely the claim that I made.
Well, like I said, I only got up to page, at
okay.
most, I got up to page 7, I think.
Okay, because that was precisely the issue. This was not something over which he had discretion. It says shall, and shall does not mean may, might, or can. If
That's
he wants
correct.
to.
But that is the second provision in that
That's
statute.
That's the one I'm claiming.
Okay, but again, I understand, Randy, but the problem is you're not, in what I've read so far, you have not specifically stated that. You've just referenced that entire statute as a whole. I understand you're saying that it's fine to put the whole statute in there when you're saying this is the statute I'm discussing. But then when you're going into the specific violation of that statute, you need to narrow it down to that specific provision.
Okay, I do, but I don't, in the introduction to the case, I don't get into extremely fine detail. First, I'm going to tell them what I'm going to tell them.
Yeah, but you don't do it. You don't do it under your failure to perform claim either. That's what I'm saying. I'm sitting right here looking at the failure to perform claim on page 4. You're still citing the whole statute instead of the specific section you're claiming he didn't perform under.
Yeah. So what's wrong with that?
Okay.
I'm giving him the whole statute. I'm not breaking it up into pieces. I catch lawyers all the fucking time quoting a little tiny piece of the case and not quoting the rest. Attorney General, first case he cites is a 20-year-old unpublished case. He cites a sentence, a dependent clause from a sentence. When I pulled up the case and added the independent clause to the front of it, it changed the meaning. And then when I put the whole sentence in the paragraph it came out of it, it changed the meaning again. So I'm putting it all in there. I put the whole...
Okay, I understand. But like I say, 1509 has an issue that I honestly don't think you're noticing. The second clause, the non-permissive clause, and the magistrate who receives the same, that is a direct reference to the first clause. Okay? And that first clause deals only with a transferred complaint, not a complaint. Yes, it does, Randy.
It does not say how the magistrate receives this claim. The magistrate receives the claim.
A complaint in accordance with Article 15.05 may be forwarded as provided by Article 15.08 to any magistrate in the state. And when the magistrate receives the forwarded complaint, then he shall issue a warrant.
Yeah, I forwarded it to him by personal fucking service.
Well, again, Randy, the argument here is going to be is what is meant and intended by forwarded.
Let them that's a ridiculous argument to bring, as it's a nonsensical argument, and that's the kind of argument that the judge will say, "Are you fucking kidding me?"
Well, they may not, but you and I both know that they do that kind of shit on a regular basis. And they do it and uphold it.
I saw that part. And I deliberately ignored that part and left it to them.
Okay.
And I'm making the claim that I forwarded to the magistrate myself.
Okay.
So, I did get that part, and I didn't want to go there. Let them go there. And that is a weakness. And frankly, this code is problematic. Every other state allows the magistrate to examine into the sufficiency of the allegation. This one doesn't. So that's problematic. If I go down and issue a warrant against you for standing on your head squawking like a chicken, he should file a complaint, then the judge has to issue a warrant. Well, maybe not that. I'd have to allege something that is a crime.
Under the law, yeah.
That you're standing on your head squawking like a chicken disturbed my peace. So I allege that you committed a disturbance of the peace by standing on your head squawking like a chicken, the judge has got to issue a warrant. That's problematic. That means I can get anybody arrested for any freaking thing I want.
Well, I agree.
So that I get it that that's problematic.
But you're missing the third provision of 1509 as well, I think. So let me clue you in what I'm reading here. And the accused, when arrested, shall be dealt with as provided in this chapter, meaning entirely chapter 15.
Yeah.
That provision ignores everything else because
15.16 says that when they're arrested on the warrant, they're to be taken directly to the nearest magistrate. Actually, the warrant will say, arrest this person and bring him before me.
Right.
That's the condition under which they can make the arrest. That's what 15.16 commands him to do. Now he can hold a proper examining trial. So that works. It's just, and the one before it that says they don't have to issue a warrant, they can issue a notice to appear. So that makes it less offensive. But they must come. There's what Texas is saying is that the magistrate can't hold an examining trial without the accused in front of him. So he's just issued a warrant, and once the person's and that's why all warrants say, arrest this person and bring him before me. Because of 15.09. He's commanded to issue a warrant if the guy's not in front of him. And then the guy gets arrested, he's brought in front of him. That all fits together nicely. It's a little uncomfortable, but it fits.
Well, you do know that a magistrate, if a mayor magistrate or a municipal clerk issues a warrant and it's being executed in a county where it was not issued, or I'm sorry, let's see.
We're going to 1570.
Okay, it doesn't matter. It's 1508, actually. In 1508, if that warrant is issued by any magistrate that is not listed, okay, in 15.06, then the peace officer receiving the warrant must take it to the nearest magistrate of that peace officer's county, who must then endorse on it the following words: let this warrant be executed in the county of. And then he has to sign it officially. That's if the warrant's issued by a municipal clerk or a mayor magistrate.
Well, they are listed.
No, they're not in 1506.
They are listed in 2.09.
They are. This statute
you're
specifically
saying,
requires
okay.
they be
So
listed in 1506.
Oh, okay, good. Well, that's reasonable.
They are magistrates as far as the other section you're talking about, but in the basis of issuing a warrant, they must be listed in 1506.
Yes. Not a warrant, a finding of probable cause.
No.
1506. The warrant, the magistrate is ordered to issue the warrant, and then when they're arrested, then this one says if they're a mayor or a clerk, then the person has to be brought before an actual magistrate listed in this chapter. And the magistrate does the trial.
This 1508 specifically says that the warrant must be taken to a magistrate of that county if it was issued by a municipal clerk who is not listed in 1506, or a mayor magistrate, which is not listed in 1506, and some magistrate of that county must put this statement and sign it on the warrant.
Oh, okay, so it must be signed off on by a
magistrate that is listed in 1506.
Okay. That's good enough. That'll work. I have criminal complaints before the mayor of Rome, Texas.
But
When he doesn't issue warrants, they figure out how to handle them. Then I'll sue him in the JP court.
yeah, 1506, a warrant of arrest issued by any county or district clerk or by any magistrate except mayors of an incorporated city or town shall extend to any part of the state, and any peace officer to whom said warrant is directed or into whose hands the same has been transferred shall be authorized to execute the same in any county of this state. So who's not listed? Municipal clerks and mayor magistrates.
Yeah.
Mayor magistrates are specifically accepted here.
Yeah.
So think about all these arrest warrants that are being issued by municipal clerks, and they're being executed with no endorsing signature.
Ooh. Ooh. Oh, Eddie Craig. When I told everybody you were an asshole, I was so right. Oh, that is choice.
But see, there's still a conflict between 1508 and 1506. Because 1508 specifically says this can only be done with a warrant issued by a magistrate. Well, the 1506 is distinguishing between a magistrate and a county or district clerk.
Okay, lost him.
Okay, 1506 specifically says that the warrant can only be executed if it's issued by a magistrate, while 1506 allows county and district clerks to issue them also.
But they must be signed off on by a magistrate.
Correct, because they themselves are not magistrates. And 1508 says that if it's not a magistrate, then it has to be endorsed by a magistrate in the county that is listed in 1506.
This gets added to my questionnaire. They're going to poop their pants.
So either they've created something that is constitutional because it must work this way, or they have created a conflict on what they were trying to do, and it is thus unconstitutional.
Well, this is okay. I will study that. That's definitely an issue I want to bring. Go to the city, and I need someone who's been arrested on a traffic warrant.
Yeah, that's signed by a municipal clerk.
Yeah. Okay, they have changed the law so that in the case of a traffic warrant, they can no longer arrest.
Is that the new 45A?
Yeah, they have to give you notice to appear. And probably once you get a failure to appear, a second time they can, but I haven't read it completely and studied it. But they have stopped these arrests for first-time failure to appear completely. I think it goes to the second time you can be arrested.
Well, the law was changed, I think, in 2017, where they could no longer arrest you for failure to appear on the citation.
That's okay. That may be the one I'm thinking of. Yeah, that may be the one I'm thinking of.
Yeah, they changed that either in 2015 or 2017. You actually must have received something either telephonically or in the mail from the court and then not appeared before they could issue a capias for you.
Okay. So I want to look at all the capious warrants that has been issued. When I sue the city of Rome, this will add to my claim substantially.
Yeah.
Okay, I will put that in my, if I can get time to get to it, I'll put that in my questionnaire. This morning I was trying to finish up a lawsuit against the city of Victoria for stealing Dr. Joe's airplane. And I'm working up the causes of action. And it's looking like I can go for, what do they call it? When the government takes somebody's properties without compensation. There's a special term for that.
Yeah.
Eminent
domain.
You know, there's a special term for taking without compensation.
Conversion.
It's an odd.
It's conversion.
Yeah, it is, but there is a specific term for that. And now changing all these pages around, I had it on one of the pages I had up, but I probably closed the page in order to make room, because I've only got 3 screens and I get them all filled up real quickly. Oh, wait. I can pull up the lawsuit. Let's see. Probably in Word.
Are you looking for the word taking?
No. I'll find it here. Let's see. Amending. Shit, I thought I had it in here. Inverse condemnation. That's what it is.
Yeah.
So I'm working that out as a cause of action.
Okay.
So, but I don't do well after 10 or 11 o'clock. My brain turns to mush.
In the morning or at night?
In the morning.
Okay.
I generally get up at 2 or 3, so I didn't get up to about 6 this morning, and before I could get into it good, my phone started blowing up. It keeps blowing up earlier and earlier.
Well, that's why I had to change my phone number before, because mine never stopped ringing 24/7. Every time somebody got pulled over or was getting arrested or accosted, they were calling me.
Well, what we need to do is set it up so that when they call you, you go on the clock.
Yeah, that would be nice. Please insert your credit card number at the following beep.
That you can get the site set up. If it's free, they'll fuck you over.
Yeah.
They call you if they get a hangnail. But we got all this group that wants everything for free, and I'm tired of fucking with them. I had this one guy who was bitched at you because you charged for your traffic seminar. And I said, what the fuck, you son of a bitch? Go out here and do your own goddamn research. Spend your whole fucking life putting this together and then give it to everybody for free. Get out of here, fucking asshole.
I addressed the same thing on a YouTube comment last night about some guy saying, I want to put together a program and do all this shit and give it away for free. And I was going like, yeah, well, let me explain to you what free means.
Worthless.
Exactly. Nobody appreciates shit they're given for free is the number one problem. Number two, you spend years of your life doing the reading, the research, the writing, the organizing, and the interpretation, and then actually have to spend your own money to go to court to fight it, to prove it out, etc., etc., and then tell me how you think it all came by the original issuer for free.
Well, that's the guys who have been raised with no discipline. They have this entitlement mentality, and I don't have much patience with an entitlement mentality anymore.
Yep. Nor do I.
So we'll get this started. I'm working on that now. I'm going to go ahead and build a WordPress site because it'll do all that backside bullshit that I'm struggling with right now. So
Okay.
then I can get this thing up and get. I think I'm going to set up a private membership association and push everybody behind that. That should get their attention a little better and should give you a degree, you and I, a degree of separation from anybody who wants to come after us.
Okay.
And all we have to do is not hold ourselves out as lawyers.
Well, Texas Constitution allows us to write and speak and discuss anything that we want to.
Yes,
So we can write whatever we want. We can sell whatever we write, as long as we make sure that we don't ever mislead them into thinking we're lawyers, or that we wrote it specifically for them.
If we only use people through the private membership association, that's in the membership association agreement, so we don't have that issue.
Right.
They may or may not read it. We don't care. But if they initial it or sign it, then they're out. Okay.
All right. Well, let's get back to it. But I just wanted to bend your ear on that and make you aware of what I'm seeing.
This is something we want this set up so we can get these people to start doing this.
Yeah.
My lawsuit. After that, the bench book, the judge's bench book for 2024 says there must be a probable cause determination. Ta-da! Got it. Got a judge in Houston who's putting his hearings on the internet. And he's doing it, and it goes ahead, it goes on to say that they must have the charges read against them, and they must state, I find probable cause.
Right, and that's that judge with the bow tie, right?
Yeah. So I've contacted his clerk or whatever she is that does his calendar.
Yeah, he's a county court at law judge, if I'm not mistaken.
Yeah, in number 5 in Harris County. And I told her what I wanted, that I watched his hearings where he holds probable cause and he does it all wrong. I want him to do it right so that he can then go down to a Senate subcommittee hearing on criminal justice and explain to them how this is supposed to be done. Because I think he would like to do that. So I'm going to send him a presentation on the examining trial and how it's supposed to be done under Chapter 16 and why this will work well. And see if I can get him to try it out and then, do it like it's, then go down to, see how it works and then go down and explain to the Senate subcommittee here. They won't listen to me, but they'll listen to a judge. I'm going to try to schmooze him into doing that. If he doesn't, I'll go down there and listen to his hearings. I'll get a docket sheet of appearances and make up a criminal complaint for everybody that's appearing. And when he's done, I'll give it to the bailiff doing the rest of the bitch.
Okay.
And when the bailiff refuses, I'll go to a justice of the peace with criminal complaints against the judge and the bailiff. And when that bailiff refuses to issue warrants, I'll go to another JP and file suit against that JP. The same fucking day.
Okay.
I think we start suing those pricks in small claims court. It only costs $50, $54 or something, and then you take a certified letter. My JP said that they have the constable serve it. Under the rules
Okay. All right. Well, I'm gonna let you get back to what you're doing, and I'm gonna jump on mine. But
Okay.
anyway, just food for thought.
Okay. Bye.
Bye.